Good morning. It's an honor to be here back in Riga. My presentation today will focus on Pillar 1 and Pillar 2 of United Nations Guiding Principles on Business and Human Rights. As Gabriel already noted, UNGPs on Business and Human Rights are one of the main documents in business and human rights. They set expectations for both companies and states in business and human rights. And I'm particularly happy that today we have this conference in Latvia and Riga also to build capacity on business and human rights in a country, and hopefully also leading towards national action plan on business and human rights. So let me walk through the basic pillars of UNGPs on business and human rights. The first pillar concerns state duty to protect human rights. The second is on a corporate responsibility to respect human rights, and the third one is access to remedy. I should note that UNGPs on business and human rights were adopted in June 2011 by United Nations Human Rights Council, which is an organ of General Assembly of United Nations, and they were adopted unanimously, and they were drafted by late Professor John Ruggie. So let us concentrate on first the nature of UNGPs on business human rights. Indeed, UNGPs on business human rights are soft law document, but as John Ruggie always has stated, they include already existing binding international rules on business and human rights. So one can say they are soft law with hard law contents, and one could also make argument that they are formal and material source of international law. As far as binding or non-binding, perhaps this discussion is not so important. What is important is the content. What do they say? So let us look at first at the first pillar, state duty to protect. This is a pillar which says what countries have to do in business and human rights. And the most critical two principles in this regard are Principle 1 and Principle 2. Foundational principles which say that states have a duty to protect human rights in a business sector. That means that they have both negative but also positive obligations in human rights. And they should also state expectations for businesses in order to respect human rights. What is really important is that states should, through national action plans or through regulatory environment, also to provide a framework for business and human rights. And of course, state can make an example, of respecting business human rights by first requesting its own, meaning state-owned enterprises where the state has a capital investment to ensure business human rights standards. Perhaps the most textbook example of a good practice here is a Norwegian state pension fund, which really put emphasis on respect on business human rights also when choosing capital investment. Then, of course, states have to provide a state oversight over businesses. Here, of course, this is obligation of conduct, is not obligation of a result, and also ensure that businesses respect human rights in their operation. It's quite important also to know that UNGPs were adopted in 2011, but in a way they already envisaged what has been happening in Europe since February 2020. Principle 7 is very critical in this regard because it says that states should make guidance for companies to operate in conflict-affected areas, ensuring heightened due diligence. This is critical for businesses which operate in Russia, Ukraine, or Israel and occupied Palestinian territories. It's also important that state institutions, are very coherent in engineering and propelling business and human rights standards, and that all departments, from executive, legislative, and judicial branch, they are on board with these business human rights standards, because often in many countries we see discrepancies between one ministry and another. A textbook example is now, for example, a disagreement between the German Ministry of Finance and German Ministry of foreign affairs, which have totally contrary position on the new forthcoming directive on corporate sustainability and due diligence. And it's also quite important to ensure policy coherence in relations with foreign investors and policy coherence when states act within international organizations. So this is the pillar one. Here are the main takes from pillar one. Of course, there's a lot of debates whether those obligations of states apply only territorially or they apply also extraterritorially. What is the nature of such obligations? Whether the states also have obligations to protect, fulfill, which are more positive of nature. And it's also quite important, to ensure when those standards are adopted and implemented, that states also ensure measuring and supervision. Measuring is super important in business and human rights. After those, states adopts those commitments and national action plan, it has to adopt national legislation to implement commitments for national action plan. But since 2011, developments have been quite, varied across the globe. Here you can see a map which was prepared, Daniel Morris, colleague of Gabriel. You can see in the blue color countries, or in green color countries which have already adopted national action plan to implement UNGPs on business and human rights. Mostly in Europe, here in Baltics, it is only Lithuania which so far adopted. Beyond Europe, there are some good examples from Southeast Asia and from Latin America. So about 30 countries so far adopted national action plan to implement UNGPs on business and human rights. And the national action plans, they have quite a few positive impacts. They can create incentive for adoption of legislation. They can clarify state and corporate obligations. They can also build capacity in state institutions, because mostly national action plans are soft law documents, where the state says what it will do in the next 5 to 10 years. But of course, some good examples from national action plans from different countries. In France, Germany, Norway, and UK, they have led to adoption of domestic legislation, due diligence guides in some countries, and some national action plans. They have measurable indicators where we can see whether the state has implemented what it promised in the plans, such as Luxembourg, Slovenia, and Switzerland, and other countries. There are some weaknesses from commitment issues to accountability issues. But let us move on to the second pillar, which says that companies should respect business and human rights standards. Those are principles from 11 onwards. The UNGPs talk about should, and at least in academia, this has been a food for discussion since their adoption, because many of my colleagues have been criticizing John Ruggie because it did not include shall, but included should. But nonetheless, the principle 11 says that companies should respect human rights. And which human rights? Internationally recognized human rights, those which are included in the 8 United Nations human rights conventions. And of course, concerning corporate responsibility to respect human rights, there has been a lot of discussions also under negotiations for the new EU directive, to which companies those obligations should apply to all companies, to a company which has one person employed, or only to the largest companies. And Ruggie took an approach of all companies. EU legislation has different thresholds from 250. German law from beginning of this year, it applies to 1,000 companies which have 1,000 employees. So there are different approaches here, but UNGPs take very broad approach. And principle 15 is also important. It requests companies to introduce the processes and policies in their business operation. And what is really important are the operational principles. These are tools how the companies introduce human rights in their business processes. The first way is to adopt a policy commitment, a policy statement. And what is really important, what is, at least in my opinion, added value of UNGPs on business human rights is Principle 17, which requests companies to introduce due diligence processes in their business operations. It's a kind of quality assurance systems in order to ensure that company does not violate human rights. I'll come to that in a minute. It basically requires companies to integrate data into business policies, and also to supervise the impact and then act on it. To adopt measures to ensure that human rights risk will be minimized and reduced. And of course, when you talk about Principle 17, here you can see the quote from there. It's about, first identify the risk in a company's business operation, and then, adopting policies which will lead to reducing those risks, and then getting data from, different stakeholders within the company, but also external stakeholders, and then drafting policies. Here, just to show you a bit more clearly, it's a graph from OECD. Here there are different phases of due diligence processes. First step is to embed responsible business conduct into business operations. Then secondly, to identify and assess adverse impact. Then try to minimize the risk, cease, prevent, mitigate impacts, track. And then fifthly, communicate with external stakeholders. Here it's very important that the company is very open and it doesn't hide information that, of course, could conflict with business confidentiality, which is an important principle in conducting business. But for example, Norwegian transparency law requests that any company which has more than 50 employees has to share the information about how they do diligence with the public, with NGOs, with civil society, which is quite, it's a broad requirements, and it will take a lot of businesses quite a lot of effort to adapt to this requirement. And then sixth step is basically provide for or cooperate, and this can be done in different steps. Either the company, provides for internal grievances, procedures, so that rights holders, in a case of alleged human rights violation, they can turn first to the company, or they can go to Ombudsman mechanism, or they can go to any other governmental mechanism. For example, here in Latvia, you have OECD National Contact Point, which is active in this regard, and it ensures that Latvian companies respect OECD guidelines for multinational enterprises. Or you can go to any other mechanisms established in private sector. Many industries, for example, a diamond industry has its own private regulation where victims and rights holders can bring their complaints. So there are different ways how rights holders and victims can voice their concerns. But all of these pillars, Pillar 2 and Pillar 2, their aim is to ensure that business and human rights is embedded in the company culture. In my mind, yesterday when I was coming here, I was reading, there was an interview in one of the German finance newspapers, Handelsblatt, and there was an interview with the German Minister of Finance, Mr. Linder, and he said that Europe does not innovate and that it only wants to regulate, and that's why he explained why his party blocked the negotiation process. But I'm not sure it's only about regulation. It's basically about changing the culture. How do you do business? Because this is not really regulation. It's basically to ensure that all of us here in Europe have a better quality of lives. That when we do work, that we work under dignified conditions, and this in a way also leads to better self-fulfillment, which propels also innovation. So one could also have a different view than Mr. Linder on that. And then, of course, when we talk about difference between corporate and state obligations and business human rights, surely states have primary obligations to ensure that human rights are respected. You know, this is a usual tenet in human rights law, that states have negative and positive obligations. But then surely corporate obligations are complementary, they are secondary. And in a way, as Gabriele already noted, there is a move from this negative nature of corporate obligations to positive nature of corporate obligations, that companies, it's not enough anymore that companies do not do harm, so they do not violate human rights, but they also have to show that they respect human rights by conducting due diligence policies, by introducing these quality insurance systems in their operations. Just to conclude, perhaps some of the lessons from other countries in the development of national action plan, business and human rights. These processes in many different countries have been very useful because they engage different stakeholders from business, government and civil society, and they define actions and also expected results, and also they ensure the responsibility of different actors. But when a country takes a new path and adopts national action plan and sets promises and objectives, it's really important that the country doesn't do that just for sake of window shopping. That national action plan also has a set of measurable indicators where government, business and civil society institutions can go back and after a few years measure what has been done. And of course, nowadays there's a lot of pressure from both within the countries, but also from regional and global arenas that the companies should adopt national action plan of business human rights. This is something that, this is necessary in human rights in order to take, respect and promotion of human rights forward, also in the business sector. So, thank you very much.